Alright, so we're just waiting here for this to get underway. And I've discovered, first thing off the bat, that my mouse does not want to work. It's making everything a little bit harder.
Off our coverage, we're following the arraignment of the suspect in the 1996 shooting death of rapper Tupac Shakur. Dwayne Keefe D. Davis will be arraigned in a Nevada court today. He was one of four suspects identified early on in this investigation and was described by authorities as the ringleader. Though he is not accused of being the actual gunman, Davis has admitted that he provided the weapon used in the drive-by shooting in prior interviews. He was arrested hours before prosecutors announced that a Nevada grand jury had indicted him on one count of murder with a deadly weapon. They also voted to add a sentencing enhancement to the murder charge for gang activity. That could add up to 20, yes, 20 additional years. That is if he is convicted. Now I'd like to bring in my guest, Richard Schoenstein, who is an incredible trial attorney, to talk about this case. Actually, you know what? Actually, even more important, our own Anjanette Levy has a look about, and a report for you, our viewers, about this. Let's go.
I'm Anjanette Levy, coming to you from the Las Vegas Strip at the spot where police found rapper Tupac Shakur shot on September 7th, 1996. Later this morning, the man accused of ordering the hit on Tupac, Dwayne Keefe D. Davis, will enter a plea to a murder charge in court. Tupac Shakur's family and friends have waited more than 27 years for this day. Las Vegas Metro Police took Davis, a South Compton Crips gang leader, into custody last Friday after a months-long grand jury investigation. Police say Davis ordered the murder of Tupac in September 1996 after Tupac and Death Row Records CEO Suge Knight jumped Davis's nephew, Orlando Anderson, at the MGM Grand over an old beef.
Dwayne Davis began to devise a plan to obtain a firearm and retaliate against Suge Knight and Mr. Shakur for what occurred inside the hotel against Mr. Anderson.
Davis confessed in a statement years ago to giving Orlando Anderson the gun to shoot Tupac, but that statement could not be used against him in court because of an agreement with police. Orlando Anderson died in a shooting in 1998, so he cannot be prosecuted. But Davis wrote about providing the gun to kill Tupac in his self-published book, Compton Street Legend. He's also granted interviews to YouTube channels in which he spoke about the shooting of Tupac Shakur.
About whether or not
right now, Dwayne Davis is being held without bail. The judge could set a trial date for him after he enters a plea later today. Stay with Law and Crime for continuing coverage of the arrest of Dwayne Keefe D. Davis. In Las Vegas, I'm Anjanette Levy.
And again, as I mentioned too, I have a great trial attorney with me, Richard Schoenstein. Richard, at a hearing to enter a plea, do you expect Keefe Davis to say not guilty, I'm not going to enter a plea, or on the off chance, guilty, you got me?
Well, I think that last one is a very slim chance. I would expect him to enter a not guilty plea. I don't know why he would do anything else.
Yeah, so the hearing really isn't that important. It's just a matter of pro forma for intent of plea and set an attorney, see if he has one, I would imagine. But let me ask you something more importantly. This case, 1996, supposedly there's statements made, supposedly there's a proffer. Tell our, which is some kind of admission, tell our viewers what a proffer is and whether or not a proffer would be admissible as an admission or a confession in a trial such as this in 2023.
All right, well, the proffer, generally speaking, a proffer is something that a witness will tell the authorities when they're, investigating a crime. And I guess it came up in the context of some other crime that was being investigated.
A drug investigation, right.
And so the police will ordinarily make a deal that the information you give us, we won't use it against you for a different purpose. So if he made a proffer about having knowledge about the murder of Tupac, it wasn't related to the crime they were investigating, and that proffer couldn't be used against him.
Okay.
That statement to those police officers. But if he later gave the same information to somebody else, then he would be subject to having that used. If he
Well, let me just interrupt you for a second, because there's a piece of information you don't know and our viewers don't know. The hearing that was supposed to occur today, it's enter a plea, has been continued to October 19th. Now, Richard, that usually happens because there's no attorney assigned, he wants to get a private counsel, or there's some other, not I won't say glitch, but there's some other reason, technical reason.
Yeah, well, that explains why it was so short.
It was shorter than my introduction.
Yeah, court hearings get adjourned all the time.
Right.
I have a line of clients who are frustrated by adjourned court hearings or other dates that we set. So that could happen for any number of reasons, including the defendant didn't have counsel or wasn't ready, or counsel wasn't ready, or somebody didn't have enough. So it's put off a couple of weeks.
Yeah, and he's without bail, so he's not going to get bail, right?
I wouldn't think so. Not for
Not an
allegation
attempted
like
murder
this.
case. Not in a murder case. But let's go to what you talked about. Supposedly this proffer then that was given, okay, to the police and the drug dealer says, yeah, I have some information. Turns reason, technical reason.
Yeah, well, that explains why it was so short.
Yeah.
You for a different purpose. So if he made a proffer about having knowledge about the murder of Tupac, it wasn't related to the crime they were investigating, and that proffer couldn't be used against him.
Okay.
That statement to those police officers. But if he later gave the same information to somebody else, then he would be subject to having
It sounded
that
like we're not
used.
getting
If
an
he-
Let me
arraignment
just
today is
interrupt
what I
you for a
thought they were
second, 'cause
saying.
there's a piece of information you don't know and our viewers don't know. The hearing that was supposed to occur today, it's enter a plea, has been continued to October 19th. Now, Richard, that usually happens because there's no attorney assigned, he wants to get a private counsel, or there's some other, not I won't say glitch. To October 19th. Now, Richard, that usually the hearing that was supposed to occur today, it's enter a plea, has been continued to October 19th. Now, Richard, that usually happens because there's no attorney assigned, he wants to get a private counsel, or there's some other, not I won't say glitch, but there's some other reason, technical reason.
Yeah, well, that explains why it was so short.
It was shorter than my introduction.
Yeah, court hearings get adjourned all the time.
Right.
I have a lot.
Then he gave statements in a book, supposedly. Why would those statements be admissible if they're not under oath and we don't actually know who actually wrote them and whether or not they were the actual statements that Keefe D made?
All right, let's break that down a little bit. So
That's a lot.
the first question is, does the proffer immunize him in statements he later makes in a book? And the answer to that is probably no, because you make a proffer to police for the purposes of this case, and that is protected. But if you go give the same information to somebody else in some other context, it can be used against you. So now let's move to statements in a book. Can statements in a book be used against him? Probably. It's not going to be hearsay. It's going to fall within multiple exceptions to the hearsay rule. It's an admission against interest.
Which makes it reliable for the
That's right.
purposes of hearsay.
That's right. That is the feeling about. That's why we keep out hearsay, because it's not me reporting what you said is not necessarily reliable unless it's something you said against your own interest. Then it's more reliable.
Well, let's go to the third thing, though. When I was reading this and prepping for this morning, and knowing that you were going to be on and could answer all of my questions,
Yeah, I don't
right?
know about that, but
Okay.
we'll try.
All right. So let's assume the statement is, I gave a gun to my nephew in the backseat of the car, but my nephew was the one who actually shot Tupac, okay? And everybody in that car is dead. The other three people are dead, all but Keefe D. But what was his intent in giving the gun? If he just says, I gave a gun, or does he have to say, I gave a gun because I wanted my nephew, I ordered him to shoot? And if no one's there to say he ordered him to shoot, how does the state prove intent?
Yeah, well, Well, the state still has to build a case. So I assume they're going to show motive by virtue of the prior dispute between this group and Tupac's group.
Would you explain what that was?
I don't know. See, you're getting more in the weeds than I am.
Okay.
My understanding of this and my recollection from almost 30 years ago is that they had some sort of altercation.
Right.
They weren't necessarily on friendly terms to
recollection.
begin with. There's some sort of altercation. So the theory is that Davis essentially ordered that Tupac would be killed. And they got in a car. The allegation in the indictment is that he procured the gun. And they were in the car, and they drove up, and he handed it to some guy in the back seat who then shot, one car to the other. So if the statement is just, I handed him the gun, that doesn't prove the rest of the case.
Right.
It doesn't prove the intent. It doesn't prove he knew the guy was going to use a gun to commit a murder. Maybe he's going to say or imply, not going to say because don't suspect he'll testify, but we'll see. That's down the road a while. Maybe he'll imply that they just had a gun for protection, as
That's what I was asking you about.
Do.
Yeah. So also, I guess the prosecution says these were two separate gangs, factions. But how do you prove that that's a motive for an enhancement, even if it's true? And there's some question about whether it's true.
Well, remember, not only are they going to try to prove there's gang activity as part of the motive theory, but they have a gang activity enhancement alleged on the murder itself, which I think elevates the degree of the murder charge. So gang activity is very much going to be part of this prosecution, as far as I can tell, and that makes it a lot more to prove, right? Now they don't just have to prove that there's a guy in a car with a gun who hands the gun to another guy who kills somebody.
Right.
They have to prove this whole web of gang activity, which is, and it's almost 30 years old.
Right.
It's not like gang activity from last week. It's 1996. The iPhone hadn't been invented.
Right. How about we
What's the
forget about that?
evidence?
And I also want to talk to you a little bit later on about Suge Knight. But in the meantime, I'd like you to listen with our viewers to a press conference, not the one this morning. Actually, there's a live presser right now. Let's go.
So that's what occurred today in court. Nothing will occur in the next couple of weeks until the next court appearance when his lawyer appears. Mr. Davis is being held on no bail. That no bail status will continue at least until his next court appearance. We will continue to ask for a no bail setting because we believe under Nevada law and the evidence in this case that the proof is evident and the presumption is great that he will be convicted of first-degree murder, and that allows us to ask for a no bail setting. I'll take some questions now.
Steve, what does it mean after so many months of work from your office to see him in court today?
Well, he's no different than any other defendant. I mean, we had a feeling this day was coming in the recent history based upon some of the events that have occurred in the last few years and few months. I like to see the person in person because on these cases, it's usually me that makes the ultimate decision on how to proceed. So I like to look at a person who's being charged with a crime in such a high-profile case. I like to look at their mannerisms. I like to look at their demeanor. I like to listen to them and kind of get a feel for their attitude.
Steve, can you say if he's been cooperating with investigators, if he's talked at all?
I understand that the day of his arrest, they were speaking with him, but I don't have anything further to say other than that.
Is there any coordination with LA about Victoria's VIG case?
I'm not going to comment on anything involving that other matter.
Elise Preston, CBS News. This is such a high-profile case, 27 years in the making. Can you talk about how that could impact the legal process moving forward?
Well, it's a cold case. It's been lingering for 27 years, but I felt there was sufficient legally admissible evidence
there's
to move
quite a bit.
forward. That's why we presented it to a grand jury. The grand jury agreed that there was probable cause
Quite
to
a bit of
return
time's
an
lapsed.
indictment. But This case is like no other case. In a court of law, we have to present sufficient legal evidence to hopefully prove his guilt beyond a reasonable doubt. Any case that's 27 years old sometimes presents some challenges, but we feel very confident that the criminal justice system will work in this case.
Mr. Wilson,
is there any reason
people
to
have
fear
wondered
for
why did it
safety
take
with
so
a
long?
gang affiliation?
Whose safety?
Davis's safety while in custody?
I don't know. I don't know anything about his safety and his contacts or his relationships with people from 27 years ago. I don't have any information regarding that.
Steve, I spoke to Tupac Shakur's brother yesterday. He says he feels that this case wouldn't have gone without a breakthrough for 27 years if Tupac had been a white man. Would this have been solved more quickly if Tupac had been white?
We don't look at the color of a person's skin. We have a number of cold cases that excellent detectives work on every single day. And whether the person is white, black, red, blue, or green, we move based upon evidence and what we can present in a court of law.
Steve, a lot of people have said, why did this take so long, especially in the last few years? Mr. Davis was very vocal about his involvement. Is there a simple answer to that question?
The simple answer is that this is an important case. We wanted to make sure we did it right. We wanted to make sure we had legally admissible evidence. We wanted to make sure that we felt comfortable that we had sufficient legal evidence. You know, if you're going to charge a person with murder, he has a right to believe that the system would only bring charges if there was sufficient legal evidence. So we waited until the point in time when we had that degree of evidence to move forward.
So one of the comments from PPD in recent years is that he has said that he has terminal cancer, he has cancer, he's very unwell. Is that playing any role in this criminal procedure?
I've heard the same comments as well, some of the statements he's made to the media. I don't know his current medical condition. I'm not going to speak to whether he's still suffering from cancer or not.
Do you think that the trial perhaps will be happening quicker because of the high profile of it, or when do you anticipate the trial likely?
Well, in a couple of weeks, when he's formally arraigned, he has a right to invoke the Speedy Trial Act, which means setting a trial within 60 days, or he can waive that right to a speedy trial, and then the trial would be set off into next year. We have to wait to see at the arraignment what he chooses to do. Anybody else? We're good. Thank you.
Thank you, sir.
Okay, so you just heard the DA from Clark County, Steve Wolfson, saying they're confident they will get a conviction, although he wasn't too sure, Richard Schoenstein, about some of the information from 27 years ago. Now, tell us how that may inure to the benefit of the defendant here, Keefe D.
All right. So
as he's known, Mr. Davis.
Mr. Davis, let's just start with a general proposition. And you know this as well as anybody because you worked on these cases and still do. No prosecution gets better with age, right? Age is the enemy.
He's not going to testify to your point. Anyhow, we're going to take a quick break here at the Law and Crime Network. More on whether or not the prosecutors, the DA in Clark County, Nevada, have solved the Tupac Shakur case and whether or not Keefe D. Davis.
I even started to notice some of the hair growing back.
And I was muted. So for me, it's kind of hard to read this. So let's look at this. So they have actually a camera showing him allegedly beating his son. And, like, to me, that's kind of a tough set of facts to overcome unless you have some valid reason. To get it thrown out. If you don't have a valid legal reason to get it thrown out, that kind of ends up being a bad set of facts for you. And I gotta figure out why my Rumble stream doesn't appear to be live. Okay. I think I fixed it now. Maybe. Yep, it's fixed now. And I gotta get it updated though to reflect the fact that the title has changed. I'm wondering how long they're going to be on break. Goodness, I don't think there's anything else that's worth watching. I rushed home. To get all this set up, and then it turned out that the arraignment was delayed. Grr. Let's see if there's any updates on the Delphi murder suspect.
No living being should ever eat processed food for every single meal of their life.
You might be able to pull up maybe some court documents here in response to things that were filed. But let me see. Because I've been waiting for the for a response to be filed and allegations made by the defense. But I don't think we have one yet.
Hi, this is Mark Barton at Sandy Hook Promise in Newtown, Connecticut.
And hi, this is Nicole Hockley, also from Sandy Hook Promise. And we wanted to bring your attention to the bill for universal background checks. And we need your signature to push this through.
This is easy. This should be easy. It's universal background checks, meaning every transfer of a firearm should be accompanied by a background check. It's already in the law. We just need to close the loophole, and you can help us do that.
So click that link and sign the petition now.
It appears that there may have been some there was motion for all future pleadings and filings to be sealed for the court's review before being released to the public. Supplemental motion for a Frank's hearing. There's been a motion filed for discovery deadline. Defendant's additional Frank's notice. And that was done on 10:03. But, other than that, it does not looking like something that's been filed to specifically address their claims, that the Otism shit is not valid. And I don't see here where they've been denied the opportunity to broadcast the trial. So that's good. So I've got to figure out how to find some of these. Motion filed, additional Frank's notice. Let's see if I can get it doing it this way. Because they're not making it publicly available. So, yeah. Ooh, but it looks like I was hoping Reddit came through with this, but they've got these like stupid screen grabs that you can barely read. Like, what on God's green earth? They posted something on Reddit, but the way they posted it, they were like, you can look it here. I was like, no, you fucking can't. You can't even enlarge it. Like, what the hell? People are so dumb. Well, I think that the stream is a bust. These people are on break probably for like 45 minutes. I'm just gonna go ahead and call it. We were wrong. We got punked. They are doing Tupac today, so sorry about that. Catch y'all later. Bye.